In the context of an important decision, the Supreme Court is going to tell us, when does lobbying Congress becomes bribery? As you know, private citizens can make a pretty healthy living by accepting payments from private corporations or other organizations to influence government decisions. There's a term for that, and that is lobbying, and it's perfectly legal. Now, the same can be said, of course, of public officials who, when they accept payments from private corporations or other organizations to influence government decisions, commit the crime of bribery. So public officials, no; private citizens, yes. But what happens when a public official becomes a private citizen? Can they accept at that point money to influence government decision? Yeah, it happens often, and it's perfectly legal. However, the question is, for how long does a public official have to remain a private citizen or have been a private citizen in order to qualify for the lawful activity of lobbying instead of being accused of bribery? And that is what the Supreme Court is trying to decide in the case of Percoco v. United States. So Percoco is this guy pictured back here. He was an aide to former New York Governor Cuomo. He accepted a $35,000 payment from a private entity to help a deal with the government go through. Except for Percoco accepted it when he was a private citizen during a short hiatus from his position of public official. And it was a very short hiatus because it lasted only 8 months. During these 8 months, he accepted the payment and then he went back to be a public official. So with all this in the background, the Supreme Court now has to decide when taking money for lobbying actually violates federal bribery laws. Can it be out for 8 months? Can it be out for a day? Can it be out for any specific amount of time? Those are rules that are not set in statutes, but affect whether lobbying becomes a federal bribery. The questions asked by the justices are actually pretty good in framing how difficult the solution to this question is. One of them asked, for example, if a public official can no longer run for office because there's a statutory limit and he or she convinces their spouse to run, can they, the former officials, now lobby legally even though the spouse may be in office as a simple puppet? This is an important question because it has repercussions on our ability to ensure that the government is making decisions that are in the best interest of the general public and not in the interest of cash-rich companies. On one side, the justices seem to be siding with Percoco, saying that federal bribery laws cannot extend that far. On the other side, they're also voicing some concern that an unlimited application of lobbying rules could sidestep federal bribery laws. We'll see what they say, but a decision is expected at the end of this session.